Hello, everyone. In this class, we will learn how to allocate the share ratio and precautions. There are several concepts. Generally, in a limited liability company, shareholders are called contributors or investors, not shareholders. So, when we usually mention contributors or investors, we usually mean shareholders. In a limited liability company, the share ratio is called the contribution ratio. This contribution ratio is the proportion of the contribution amount that each shareholder should pay to the company's registered capital. Another concept is the type of enterprise. When registering a company, you will choose from 4 types of enterprise. One of them is called limited liability company, sole proprietorship by a natural person. This means that the company has only one shareholder, and this shareholder is a natural person. Natural person means anyone, everyone. The corresponding one is a legal person or corporate legal person. The corporate legal person can be not only an individual, but also a shareholder in the name of a company. So, when a company has only one shareholder and he is a corporate legal person, this company is called a limited liability company. Sole proprietorship, if the company has 2 or more shareholders, and the largest shareholder who dominates the company is a natural person. Then this company is called a limited liability company, invested or controlled by a natural person. If there are 2 or more shareholders in the company, but the dominant shareholder is a corporate legal person, then this company is called a limited liability company, legal person investment or holding. So the 4 types of companies when registering a company are the above 4 items. If a company has only one shareholder, then the company is called a one-person limited company. One-person limited company has both advantages and disadvantages. Article 63 of the Company Law of the People's Republic of China clearly stipulates, if the shareholder of a one-person limited liability company cannot prove that the shareholder's personal assets are separate from the company's assets, then the shareholder of a one-person limited liability company needs to bear unlimited liability for the company's debts. For a limited liability company, when you are the sole shareholder, you will most likely bear unlimited liability because it is difficult for you to prove that the company assets and personal assets are separate from each other. Unless you can do the company's finances very rigorously and record every account clearly, it is difficult to prove the distinction between company assets and personal assets if there is any financial transaction between individuals and companies. So, in order to avoid such risks and avoid unlimited liability, it is best not to register a one-person limited company. Therefore, you can add an extra shareholder when registering a company to become a multi-person limited company. In this way, you only need to bear the corresponding limited liability. This new shareholder can be a relative, friend, partner, etc., but it must not be a husband and wife relationship. If 2 shareholders under a company are husband and wife, then the company will also be regarded as a one-person limited company. From the perspective of responsibility, as long as it is not a husband and wife relationship, other relationships are fine. After comparison, it is found that ni-person limited company has many disadvantages. But in some cases, the company has only one shareholder and cannot find a second person to serve as a shareholder. In this case, we should not worry too much about taking on unlimited liability, which is not so terrible in reality. First of all, we need to understand what unlimited liability is. When your company is in debt, the company's assets should be used to repay it first. When the company's funds cannot repay the debt, if there are multiple shareholders, it needs to bear limited liability. Each shareholder does not need to repay the debt additionally. However, if the company has only one shareholder, then the shareholder's personal assets need to be used to repay the company's debt. However, if the company is a one-person limited company, the company belongs to the personal property of the shareholders. Shareholders have absolute say, so when the company has debts, it is natural for the shareholders to repay them. Individual business owners and sole proprietorships have only one shareholder, and the shareholder bears unlimited liability. So, there is no need to worry too much about unlimited liability. If there is no trustworthy partner to distribute shares together when the company is registered, you can also be a shareholder alone, and when there is a suitable candidate in the future, you can increase shareholders at any time and distribute shares through capital increase, which is also very easy. However, what rights do shareholders have? They are mainly divided into 2 categories: income rights and participation rights. The income rights refer to the right to obtain income based on shares. The income also includes two categories. One is dividend income. When the company makes a profit, it distributes dividends to shareholders according to the proportion of shares, which is dividend income. The second is to make a profit by transferring shares. For example, in the early stage of the company's operation, the company's equity value is only 1 million yuan. In the future, after the company has developed, the equity value will reach 10 million yuan. At this time, the company's equity is sold at a price of 10 million yuan. Then, excluding the principal of 1 million yuan, the profit from the sale of equity is 9 million yuan, which is profit through transfer. These are the two income rights of shareholders. Another right of participation, which includes voting decision-making rights and right to know. Voting decision-making rights means that when the company has major events or directions that need to be decided, a shareholders' meeting will be held, and the voting ratio will be determined according to the proportion of shares held by each shareholder. For example, if a shareholder holds 50% of the shares, he has half of the voting rights, while all other shareholders together only have half. The right to know is mainly for some small shareholders. Because in the process of the management of the company by the major shareholders, it will cause information blockage, which will affect the right to know of the small shareholders. The so-called right to know means that shareholders have the right to check the company's financial statements. This includes participating in the company's board of directors meetings, shareholders meetings, and important decision-making meetings for company management. The obligations of shareholders are mainly to pay the registered capital and bear the responsibilities corresponding to the registered amount. The proportion of responsibilities is the same as the proportion of the registered amount. However, this responsibility only takes effect after the shareholders have paid the registered capital. The responsibilities are limited to the registered capital limit actually paid by the shareholders. The above are the rights and obligations of shareholders. There is another question. Some major shareholders of some companies want to distribute shares to others while retaining the control of the company, to reduce the shareholding while actually firmly controlling the company. This situation is not difficult to achieve. Company control depends on three key figures. The first is 67% absolute control. The second is 51% relative control. The third is 34% veto power. First, let me explain 67% absolute controlling rights. When we talked about shareholder rights earlier, we mentioned that there is a voting decision-making right among the shareholders' participation rights. This voting decision-making right needs to be based on the shareholders' shareholding ratio. There is a clear provision in China's company law of the People's Republic of China. When a company makes the following important decisions, it must be approved by more than 2/3 of the voting rate of the company. 1. The company needs to be deregistered and liquidated. 2. The company needs to upgrade its organizational type. For example, if a company is upgraded from a limited liability company to a joint stock company, this situation usually only exists when the company is about to go public. 3. When the company needs to amend the Articles of Association. The Articles of Association are some important regulations for the company's operation, so the amendment of the Articles of Association requires at least 2/3 of the votes to be passed. 4. When the company plans to acquire other companies. 5. When the company is planned to be acquired by other companies. 6. When the company needs to increase the registered capital. 7. When the company needs to reduce the registered capital. The above 7 points require more than 2/3 of the votes to be passed, so it is called absolute control. 51% relative controlling rights means that when shareholders own more than half of the company's shares, except for the 7 important decisions mentioned above, the remaining decisions can be passed with more than half of the votes. For example, the company plans to replace the legal person, directors, supervisors, and managers, and other personnel changes. Including some daily company decisions, only more than half of the votes are needed to pass. But this also depends on whether there is a separate agreement in the company's Articles of Association. If there is no special agreement, generally more than half of the votes can pass. Next, let me explain why 34% is called a veto. We mentioned above that absolute control requires at least 2/3 of the votes to pass. That is, it must exceed 66.666% of the votes. However, if a shareholder has at least 34% of the shares, then the shares of all other shareholders add up to at most 66%. then it does not reach the 2/3 voting rate of absolute control. So, if you have at least 34% of the voting rate, you have a veto power over major events. If you want to have a veto over the company's decision-making power, you must have at least 34% of the shares. Usually, the major shareholders of a company are in the process of equity distribution. Because the equity distribution is too dispersed, they gradually lose 67% of the absolute controlling rights and 51% of the relative controlling rights. So, as a company manager, how can you distribute the shares and ensure that you do not lose the control of the company? There are 3 common ways of equity distribution. The first one is name registration. When the company is initially established, the company manager will ask each shareholder to register his name in the register of the Industrial and Commercial Bureau. Every shareholder, including founders, partners, etc., needs to register his name in the register regardless of the amount of equity. This is name registration. However, many founders worry that the increase in partners in the future will gradually dilute their own shares. In this way, the founders of the company will gradually lose control. This problem can be solved by the second method, proxy holding agreement. Proxy holding agreement means that the partners of a company do not directly name registration and are not directly reflected as shareholders of a limited company. Instead, the names of these partners are placed under the founder, which means that all the shares of the company belong to the founder. The founder then takes out a part of his shares and signs a proxy holding agreement with the partners. This part of the founder's shares is agreed with other partners, and the founder holds them on their behalf. Although they do not hold company shares, the partners in the proxy holding agreement have the company's dividend rights, and all decision-making and control rights are handed over to the founder. In this way, the founder can achieve both the guarantee of the partner's dividends and the concentration of the company's control and decision-making power on himself. However, this equity distribution method will make the partners very insecure. Partners will worry that their shares and decision-making power will be held by the founder. What if the partner does not cooperate or does not admit it? In fact, you don't need to worry too much about this. After the proxy holding agreement is signed, it will be legally protected and effective. But this premise requires mutual recognition by both parties. This agreement is limited to the partners and the founder, and no one else is aware of it. So, once the founder fails to perform the agreement, as a partner, you can protect your rights and interests through the law. After winning the lawsuit, the shares of the partner will be registered and recorded in the list of the Industrial and Commercial Bureau. After winning the lawsuit, the shares of the partner will be registered and recorded in the list of the Industrial and Commercial Bureau. However, this process is relatively troublesome. For partners, it is relatively insecure to agree on their own interests through the proxy holding agreement. But there is no need to worry too much because there are legal constraints. When you are the founder of a company, you actually face more difficulties. The essence of equity distribution is a game through which each partner's share balance is pursued. Equity distribution itself is a process of buying people's hearts with money. However, through the proxy holding agreement, the founder distributes the benefits to the partners, but does not get equal trust and cohesion. This is the disadvantage of the proxy holding agreement. In the face of this problem, there is actually a compromise solution. That is the third way of share distribution, building a shareholding platform. In this way, the founder no longer holds the partner's shares on behalf of the founder, nor does it need to let the partner directly register a name. Instead, the founder reestablishes a new limited partnership as a shareholding platform. This limited partnership, like a normal company, also needs a business license. There are 2 types of limited partnerships. The first type is called general partner. The other type is called limited partner. General partners need to bear unlimited liability but have full decision-making power and control. This means that all control of the entire limited partnership is concentrated in the general partner. In a limited partnership, a limited partner only bears limited liability, but he has no decision-making power or control power, and only has the right to dividend income. In a limited partnership, a limited partner only bears limited liability. However, he has no decision-making power or control power, and only has the right to dividend income. Then we can let the founder serve as the general partner and let the partners and small shareholders serve as limited partners. In this way, as a partner, you can distribute shares without losing control of the company. It can also increase the cohesion of partners. As a partner or a small shareholder, You can enjoy dividends without worrying about damaging your own interests. Kill two birds with one stone. So, how can this method be implemented? A limited partnership can be a corporate shareholder of an enterprise and then distribute shares to general partners and limited partners. Among them, the general partner has full control over the entire limited partnership, and the general partner is held by the company's founder. The founder is also a shareholder of the limited company, so the founder can indirectly obtain full control of the entire company. The limited partner is an indirect shareholder of a limited company. When the company makes a profit, it is directly distributed to the limited partnership, and the limited partnership then distributes the profit to the limited partner. In this way, the limited partner can reasonably get the company's dividends without worrying about interference from the founder or major shareholder, which is safer and more secure. Okay, the above content is to let business operators understand how to distribute company shares without losing company control. At present, most of the limited liability companies with domestic capital structure in China basically adopt this building a shareholding platform method. Thank you for watching. See you next time.